Hello friends, in the series on the income tax cases, today we will discuss a very important case on the limitation period for passing the penalty orders, that is section 275 subsection 1 clause C. In the present case, a very pertinent issue was before the Honorable Delhi High Court that if the cause of initiating the penalty has occurred and the penalties are initiated after 5 years of that cause and then penalty orders are passed, so whether in that case those penalty orders should be quashed on the basis of inordinate delay. This issue has been decided by the Honorable Court in the case of Commissioner of Income Tax TDS versus ADMA Solutions Pvt Limited, and this case is reported in 473 ITR at page number 36. And the date of the judgment is 12th November 2024. In the present case, there was a survey under section 133A on the assessee, and in that survey it was found by the survey team that there are some lapses on the part of the assessee for not complying the provisions of TDS, like non-deduction of TDS and furnishing the TDS statements on time. This survey was conducted on 21st January 2008. After that, the department went into a deep sleep for 5 years, and after 5 years, the penalty notices were sent to the assessee on 31st January 2013 after 5 years, and then penalty orders were passed on 29th July 2013 under section 271. Section 271C and section 272 capital A subsection 2 clause C and section 272 capital A subsection 2 clause K. When these matters were before CIT appeal, because the penalty was imposed for the non-compliance of the TDS provisions, the assessee also pleaded that the name of the assessee has changed but the entity was the same. So the penalty orders have been passed in the old name, so the penalty should be deleted on this ground. And the CIT appeal was carried away by this argument of the assessee and gave the relief to the assessee and deleted the penalty orders just on the basis that the penalty orders have been passed in the old name, so the penalty orders are bad in law. When the department moved to the tribunal also upheld the order of the deletion of the penalty and also deleted the penalty on the ground that the penalty orders have been passed with inordinate delay. On the pursuit of section 275 subsection 1 clause C, it becomes very clear that the penalty orders are to be passed within 6 months from the end of the month in which the penalty is initiated, but there is no time given in section 275 subsection 1 clause C for the initiation of the penalty. But for this, the tribunal said that it doesn't mean that the penalty can be initiated at any time or by taking any leverage of time, since in the present case the cause of action has happened in 2008. So practically the initiation of penalty should be from that date. When this matter was before the High Court was not convinced with the order of the tribunal so far as the quashing of the penalty on the ground that the penalty orders has been passed in the old name. So up to that extent, the court was not convinced with the tribunal and said that if the name has changed, not the entity has changed, and the penalty orders are passed in the old name, so for that the penalty should not be quashed. The Delhi High Court relied on 2 judgments of the Delhi High Court. The first case is CIT versus Jagat Novel Exhibitors Pvt Limited 2013, and the second case is Skylight Hospitality LLP versus Assistant Commissioner of Income Tax, which is 2018 judgment. So the court said that the benefit of section 292B should be given to the revenue to that extent. But as far as the passing of the penalty orders after 5 years are concerned, for this the Honorable Delhi High Court was convinced with the tribunal and said that in the present case, since the cause of action has happened in 2008, the penalty orders have not been passed as per the mandate of section 275 subsection 1 clause C, and hence deleted the penalty on the ground of inordinate delay in passing the penalty orders. At the end of this video, once again I am repeating the name of the case. The name of the case is Commissioner of Income Tax TDS versus ADMA Solutions Pvt Limited, and this case is reported in 473 ITR at page number 36, and the date of the judgment is 12th November 2024. Thank you, friends.